Hi guys, welcome to the channel. Thank you for joining me. Thank you for your continued support. Right, so as you know, when the Labour government took over, there were a number of things that the Conservative government were looking at, and some of those things got to the stage where they had completed consultations and things like that. Other things were kind of left to because they didn't think they would work, or because there was public opinion against them, stuff like that. And then we know that when the Labour government got in, some of those things they have continued to look at, including the reduction of the welfare budget. And the green paper or white paper, however you want to call it, that was something that they were looking at from the previous government. But someone has taken them to court because they believe that consultation wasn't fair. And I'm going to show you an article now where it explains a bit more about it. So let's take a look. Okay, so here we are. DWP's misleading and unfair consultation disability benefit reforms unlawful High Court rules. So the Tory ministers presented reforms to the disability benefits as a way to support disabled people into work, and they would have seen many worse off by at least £416.19 per month. So this is a consultation that the Conservatives started, but the Labour Party did say that they were looking at it, but perhaps doing their own thing with it. So again, it was something which was a little bit controversial at the time. The Department for Work and Pensions consultation into plans to slash billions of pounds from disability benefits has been ruled unlawful in a damning High Court judgment. In a judgment published this morning, Mr Justice Calver said that the judicial review brought by disability activist Ellen Clifford had surmounted the substantial hurdle of establishing that the consultation was so unfair as to be unlawful. Repeatedly describing the DWP consultation in autumn 23 as misleading, rushed and unfair. The consultation documents failed to highlight the substantial loss of benefits facing those affected by the proposals. The consultation gave the misleading impression that changes were required to ensure deaf and disabled people could access employment support when they could already choose to access this voluntarily. And despite the consultation presenting the changes being solely about helping disabled people into work, in reality, cost savings was at least one of the two bases, if not the central base, on which decisions would be taken, on which policies would be taken forward by the government. The 8-week consultation was also seen as unlawful because it was too short. The unfair burden upon vulnerable people of having to deal with yet further consultation process at this time, as such short notice cannot be overstated. This is what Mr Justice Calver said in his judgment. In setting the consultation period, the Secretary of State for Work and Pensions ought to have had more regard to the attributes of those people who would be affected by those proposals. These were proposals which in particular could potentially drive vulnerable people into poverty, as well as adversely affecting disabled people and substantial risk claimants who have mental health conditions and that particular thing as well. I am overjoyed that the court had recognised the importance of properly consulting deaf and disabled people on reforms that would leave many worse off by at least £416 a month. This is what Clifford said. It is a life or death issue. One internal DWP estimate, which we only know about because of my legal challenge, indicated that 100,000 disabled people who are classed as highly vulnerable will be pushed into absolute poverty by 2026-2027. As a result of the types of cuts they proposed in the consultation. We now urge the government to rethink these proposals and make the safety and well-being of disabled claimants their priority, as well as commit to consulting us fairly and lawfully in the future. Now, it goes on to say that yes, that an internal DWP impact assessment said 100,000 people could be pushed into poverty by these measures. Now, it says here that today's judgment does not require the current government to drop the proposals or rerun the consultation, but if it tried to implement the cuts based on a consultation that has now been ruled unlawful, further successful legal action would likely follow. The government may choose to rerun the consultation or find other ways to achieve the planned savings, which amounted to nearly £3 billion over 4 years. And they go on to say that the theory they have is the reason why the government delayed this benefits paper until the spring of next year is because they were waiting for this judicial review. So now this is out and that consultation has been found unlawful. I think they're probably going to have to rethink it, either do another consultation or do something completely different. So this is good news for people who were worried about this consultation back in 23, because it was unlawful and that's been judged now. So even if they were to go through with it, there are going to be people who are going to go back to court and get it ruled unlawful again. So, you know, in my personal belief, I don't believe they would want to do that again and go through the same process again. So hopefully this means they're going to change their plans, at least in some part. But let me know down in the comment section what you think about this. Obviously, it's a good thing that it's been ruled unlawful. And hopefully this means that the Labour Party will sit up and realise that, you know, you can't just keep beating disabled people down without some kind of redress. And so yeah, let me know down in the comment section what you think. I would love to hear your thoughts. And if you've got this far, please do consider subscribing to keep up to date with all the news in DWP and the benefit system. And I will see you next time.